Hello there and welcome to this online paper. My name is Stephen Egan and I'm a PhD researcher at Queen's University Belfast. I upload this quite long paper today as a contribution to the excellent British Association for Irish Studies virtual conference, which many of us have been able to enjoy throughout the month of May, but as also as a small project to mark the centenary of the establishment of the Dáil Courts in June of 1920. The Dáil Éireann Courts, which I will henceforth refer to as just Dáil Courts for the sake of simplicity, are often forgotten by scholars of the Irish Revolution, or at best, they are relegated to a footnote of history. Outside of academia, the Irish Revolution is enshrined by many as a military success story, with the Irish Republican Army grinding down the resolve of both the British Army and the Royal Irish Constabulary, forcing Great Britain to the negotiation table in 1921. The reality is that the Irish Revolution is an incredibly complicated and multifaceted machine, and that such simplistic narratives are largely inaccurate and are generally unhelpful in understanding the events that actually transpired. Today, during this decade of centenaries, the military campaign has been extremely well documented, usually at the expense of the less violent side of the Irish Revolution. This paper aims to shine a light into this less glamorous, almost administrative side of the Irish Revolution, by presenting a county-based study of the Dáil Courts. I am not the first scholar to study these courts. Mary Kotsonoris, a former judge and historian, is at the moment the most prolific author on these courts, but so far she has only really written on the national picture. Others, such as Marie Coleman, have included the Dáil Courts as part of their broader county-wide analyses of the revolutionary years, in Coleman's case examining the courts of County Longford. The late David Fitzpatrick also has examined the courts of Clare. And what this means is that over time, scholars are beginning to piece together individual microhistorical accounts of the Dáil Courts, which collectively build up the national picture. In fact, perhaps the greatest stride towards such a study has been produced by a master's student, Joost Westerwiesel, who examined the courts of Donegal, Monaghan, Cork, Westmeath, and Limerick back in 2013. My work on the Offaly Dáil Courts is only but one more piece of the broader national jigsaw. The general lack of scholarship on the topic does not diminish these courts' importance in the Irish Revolution. While these courts existed for a relatively short amount of time, Fitzpatrick speculated that it may well be that one 5-shilling decree for trespass in a remote western parish was worth far more than a dozen declarations of independence. As the heaviest of the fighting of the War of Independence came in Dublin, Cork and Kerry, for most people across the island of Ireland, the Dáil Courts became the regular, day-to-day face of Dáil Éireann's authority and a symbol of their legitimacy to rule in Ireland. This online paper is split into 3 parts. Firstly, I will detail the development of the Dáil Courts, what they were, what they did, and why they were needed. The second then builds on this, and we begin to look at the Offaly Courts themselves. And finally, in the last section, I will go into depth about what kind of cases there were at the Offaly Courts. Was this a typical experience compared to the other studies that we have? And what does this tell us about the experience of people in Offaly during the revolutionary years? The conceptual origins of what would become known as the Dáil Courts legal system can be traced back to the writings of Arthur Griffith, the founder of Sinn Féin. As far back as 1905 at the National Convention, Griffith postulated that a future self-governing Ireland would require the creation of independent courts, although he gave little indication as to the minutiae of running such a hypothetical administration. However, not even Griffith could have foreseen the radical change in the Irish political sphere which was to take place over the next 15 years. While civil war over the question of Home Rule was narrowly averted in 1914 by the outbreak of the First World War, the political discourse of Irish history was revolutionised by events closer to home. On the 24th of April 1916, members of the Irish Volunteers, the Irish Citizen Army and Common Nabarm, led by 7 members of the Military Council of the Irish Republican Brotherhood, proclaimed a free Irish Republic and seized positions across central Dublin. By the 29th of April, the Easter Rising, as it's now known, was over, and the fledgling republic extinguished. The insurrection in itself was not the transformative act, but it was the subsequent British response that followed that would set Ireland ultimately on the path to independence. The execution of the leaders of the Rising paved the way for the rise of Irish republicanism to politically supersede the constitutional Irish nationalist group. At the 1918 general election, Sinn Féin won a sweeping landslide of Irish seats, taking 73 out of 105 MPs, although controversially many of these seats were indeed uncontested. Within weeks of the general election, on the 21st of January 1919, the elected Sinn Féin representatives reasserted Ireland's independence from the British Empire and established Dáil Éireann, the Irish Parliament. At this point, trapped between two competing legislatures, issues of legal importance began to emerge. As Plato reminds us, necessity is the mother of invention, and this principle holds true for the motivations behind the swift creation of a brand new set of courts in Ireland. The first of these courts can actually be traced to County Clare in the west. With the breakout of hostilities in January, civil unrest and land agitation in early 1919 began to threaten what Kotsonoris has termed, quote, the renewed pride in national identity and hope of independence, end quote. In less idealistic terms, some opportunists, sensing the changing tides, desired to benefit themselves out of the political confusion, and thus disputes, usually over land or livestock, began to emerge more frequently. Consequently, the local leadership of Sinn Féin and active members of the Irish Volunteers took steps to establish themselves as the mediators for the localised land crisis, which had taken hold across the rural West. These unofficial mediation courts, which I should emphasise are not official in any capacity, became informally known at the time as Sinn Féin Courts, due to the prominent role played by Sinn Féin members. This informal Sinn Féin court title actually transcends beyond the period, even permeating some modern academic literature, such as in the title of David Foxton's 2008 Revolutionary Lawyers, Sinn Féin and Crown Courts, where it is used to generalise all of the non-Crown courts operating throughout the period, including the Dáil Courts. However, henceforth I shall refrain from using the term Sinn Féin court due to its overgeneralised nature and the ambiguity to which specific types of courts are actually being discussed. On the 18th of June 1919, Decree No. 8 of Session No. 4 of Dáil Éireann formally established the arbitration courts. As the name implies, the arbitration courts focused on voluntary land dispute resolution. This decree also formally incorporated and built upon the foundations already laid in Clare's mediation courts, but called for an expansion of the courts on a national scale. Ireland, going back as far as the time of Daniel O'Connell in the 1840s, had a long-established problem of land agitation, especially in the years of the Land War. But the rise in arbitration courts highlights an interesting and perhaps unexpected dynamic of the Irish Revolution. The arbitration courts were the first precursor to the Dáil Courts, and they were established to prevent land agitation. In doing so, their objective was to maintain the current land system, which could then be addressed later on in full after independence had been won. For an organisation and for a movement that on the face of it would seem quite revolutionary, this highlights the complex underlying political nature of the Dáil Courts, given how a republican facade concealed an inner conservatism at the core of both its ideology and its objectives. In fact, Arthur Griffith recognised that land agitation had the potential to destroy the United Nationalist Front and thus end any prospect of Republican success. To avert this, the arbitration courts were established quickly to give and enforce conservative judgments to prevent the potential fracturing of the Republican movement, while simultaneously attempting to retain the support of small farmers and landless labourers who might otherwise have withdrawn their support for Irish republicanism. Ironically, the British authorities in Ireland were also content to allow these courts to act without interference, given that they also wished to suppress agrarian unrest. However, in 1919 it appears that they did not fully appreciate the extent of the propaganda victory which they were handing over to the Dáil. Despite their successes, the arbitration courts were severely flawed. Ultimately, arbitration courts were voluntary assemblies, designed in order to deal with agrarian strife in the west of Ireland, which had then been exacerbated by the political turmoil now rippling across the country. As a result of this, these courts almost exclusively existed in the west of Ireland, leaving the rest of the island under the influence of the British Crown Courts. The arbitration courts, because they acted on a voluntary basis, did not legally challenge the British court system in Ireland. In essence, the arbitration courts were little more than local people voluntarily agreeing to resolve their own problems and pass their own solutions. If an affronted party didn't wish to take part, they didn't have to, and they couldn't be compelled to, at least legally. Whilst there may well be social consequences to non-participation, there was none written down in law. As a result of these shortcomings, the Minister for Home Affairs, Arthur Griffith, and his ally and the successor in the post, Austin Stack, desired to upgrade the courts further, with Stack submitting a report detailing the need for some degree of coercive jurisdiction. The successor court system, the Dáil Éireann Courts, were a sizable upgrade from the arbitration courts, and went further by directly affronting the rule of British law in Ireland. Dáil Éireann forcibly proclaimed the sovereign right to the judicial system of Ireland by decree on the 29th of June 1920, over a full year after the arbitration courts were enacted. The decree brought the two legal systems operating on the island at the time into open and direct conflict with one another. Both systems claimed legal sovereignty over the entire island of Ireland, but over the course of late 1920 and 1921, the British Crown Courts were systematically undermined. Ironically, the two sets of courts also shared common aims: to maintain and quell social unrest, which had begun to spread as the conflict spiralled out of control around the island, ended a general decline of law and order, and to provide justice to wronged parties. The Dáil Courts went further than conservatively soothing land agitation, by attempting to achieve social sedition of widespread crime and disorder via reinstalling and maintaining justice. As the Crown Courts crumbled along with the decline of the RIC, law and order deteriorated rapidly, and as a result there was a clear demand for a more powerful court system than the arbitration courts. As a consequence, the Dáil Courts were established, offering both criminal and civil justice. The fall of the Crown Courts also offered a golden opportunity to the Republican movement, the chance to present Dáil Éireann as a credible and legitimate alternative to British rule in Ireland by successfully filling the void left by the Crown Courts with Dáil Courts. In the process of establishing these courts, law and order could be restored. Amicable relations with the people of Ireland was a key objective on the Dáil Court agenda, which was a dynamic inherently shaped by the ideology and interpretation of case rulings. Part of this dynamic became a sensitivity to be seen as fair. The testimony of the Dáil Courts in this regard can be examined not just on a case-by-case basis, but also by looking at the social demographic groups and communities using and accessing Dáil Court services. As both Foxton and Coleman argue, the ultimate testimony to the success of these courts was the willingness of the elements of society who were diametrically opposed to republicanism still engaged with Dáil Court structures, most prominently Unionists. This move to appeal to all sections of political opinions perplexed the British establishment and significantly boosted the image and the credibility of Dáil Éireann in the eyes of its opponents. The primary evidence also supports Foxton and Coleman's claims. The Lord Mayor of Cork, Terence McSweeney, who incidentally was arrested while presiding over a district Dáil Court in Cork in August 1920, noted that in his correspondence, Unionists were, quote, quite willing to submit cases to such courts if guaranteed a fair hearing, end quote. Now naturally this can be exaggerated out of proportion. One must not forget that in the absence of Crown Courts and the RIC to enforce order, that in most of Ireland, or certainly excluding the North East, Unionists were typically outnumbered and geographically isolated in small pockets. It would not be an unreasonable prospect, therefore, considering the intimidation campaign of the IRA, for these people to feel a political and social pressure to conform to the usurping Dáil Court system, and just simply hope for a fair outcome. Perhaps to some, justice at the Dáil Courts was better than no justice at all. The decline of the Crown Courts may have left ordinary people with no other choice but to use Dáil Courts, but they probably would have used Crown Courts should they have been available. In truth, such a dynamic is extremely difficult to definitively prove, but nonetheless is an interesting point of discussion, especially when we consider County Offaly as an example of a plantation county experiment which inherently changed both the political and religious landscapes of the region. Beyond Offaly, though, despite the chaos of the War of Independence, the Dáil Courts gradually established themselves across the rest of the island, with varying degrees of success. Between 1920 and 1923, 31 out of 32 counties held Dáil Court sessions. Only County Antrim and the small parts of Belfast located in County Down over the River Lagan never bore witness to any Dáil Court activity. All of the other 31 counties had some level of Dáil Court activity, to some with lesser or greater extent. As the War of Independence progressed, British forces had become increasingly powerless to restore law and order and gain the upper hand in the legal dichotomy at play. According to Foxton, the leading author on the Crown Courts of the period, by the July of 1920, only 47 individuals had been convicted for political offences and 76 were awaiting trial, but juries could not be summoned or trusted to deliver a conviction charge, even in the face of overwhelming evidence to the contrary. Compare this to the fact that the RIC had 5,599 indictable offences on record from the January of July of 1920. Correspondents from Dublin Castle reported that the Dáil Courts were doing more harm to the prestige of the British government than assassinations, which is testimony to just how seriously the British authorities regarded these courts, and also points to their perceived success from the British position. In the face of their legal system collapsing and facing a difficult guerrilla war strategy, the British passed the Restoration of Order Act in August. The Act aimed to suppress the IRA militarily and shut down these courts once and for all. Somewhat ironically, though, it is at this point that the IRA reformed into the famous flying columns, which ended up being arguably the most effective armed response against British forces. The Restoration of Order Act did, however, make some impact upon the Dáil Court system by driving it underground. Whereas the courts had been previously able to operate with relative ease until this point, in the face of the crackdown, there is a distinct shift nationally from August 1920 onwards. In areas where the IRA were less active, for a variety of reasons, the Dáil Courts were generally suppressed more effectively than those areas where the IRA had relative control. This correlation is unsurprising, and this point has an explicit point of impact with specific regards to the Offaly Courts, which I'll come on to shortly. At the national level, the truce marked a significant turning point for the fate of the Dáil Courts. After the 11th of July 1921, the terms of the truce allowed the Dáil Courts to continue to operate within a legal grey zone, since the treaty did not explicitly deny them the right to operate. Whilst this did not allow Dáil Courts to operate with complete impunity, it did mean that their proceedings could take place without the fear of direct military assaults, and that the RIC were generally unwilling to intervene in raids without military support. Occasionally, the RIC would raid courts and shut them down, although under the guise of breaking up a political gathering, which were banned under the truce agreement. However, since no crime had technically been committed, the RIC were unable to seize evidence from the courtroom, and as a result, the amount of detail recorded in the court papers increased dramatically. For the most part, however, the RIC used the time after the truce to gain intelligence on the operation of the courts. Since most courts now operated freely again, the police and their network of informers were able to gain fairly detailed activity accounts of individual sessions. Typical details of the reports included locations, the names of the justices presiding, and occasionally even the names of those bringing cases forward. What they appear to have found particularly difficult to ascertain was the content of the cases, but it is also possible that this was not regarded as particularly important to be collected. These details were usually kept by the clerks of the courts. After the truce, the clerks of the courts began to keep detailed paper documents regarding the operation of the court. Of course, until the truce, it would have been outrageously dangerous to have kept such records during the conflict. Had such papers fallen into the hands of the RIC or the army, it would have pointed directly to all of the names and addresses of those using the court, as well as all of the justices who presided. Finally then, before we get into the details of the Offaly Court papers, we must take just one more step back into looking at the courts. We must examine the structure. The structure of the Dáil Courts was a hierarchical model, loosely based on the British Crown Court system which it sought to supplant. At the lowest level were the parish courts, which, as the name suggests, were the boundaries in which the court operated. The parish courts presided over the lowest level of cases and considered all cases up to a maximum value of £10. The next level up was the district court, which dealt with cases of a more serious nature and those dealing up to £100. Appeals from the parish courts were also heard by the district courts up to 3 times a year, which allowed a number of cases to be heard in a single sitting, rather than having them repeatedly coming up. Appeals from the district court were then passed on to the circuit court, of which there were 4 in the country, loosely speaking 1 per province. Finally, at the top level of the Dáil Court system was the Supreme Court, which was held exclusively in Dublin, and heard any cases of a greater value of £100 or appeals from the circuit courts. The staff involved in a Dáil Court was generally the same though at all levels. 3 judges held the court at each level. At the parish level, there was no bar to being a judge, which included no legal education of any kind. The law of Ireland was settled on an emphasis of common sense and some kind of loose interpretation of what laws already existed. At the higher levels, some legal education was required, with already professional judges with Sinn Féin sympathies taking seats at the Supreme Court. It is in Who Could Be a Judge of the courts that we get a glimpse into how progressive they could be. Unusually for this era, this included allowing women to serve as judges. For those of you familiar with Ken Loach's 2006 film The Wind That Shakes the Barley, there's a scene in which it depicts some kind of historical truth, in which it depicts the argument after the proceedings of a Dáil Court, with all 3 judges portrayed by women, which you can see on the screen now. Whilst to my knowledge no Dáil Court ever operated with 3 women presiding, it does highlight that women were given prominent positions within this court and legal system, which is in stark contrast to the British Crown Courts at the time and to the change of treatment in women after the revolutionary years in the Irish Free State and beyond. In most cases, though, 3 men presided as the judges. Usually, 1 seat was given to the local clergyman, who was an educated person and is seen as a community leader and of someone of great respect. The other 2 seats were usually given to local prominent community leaders, although not necessarily political figures, and usually these people would have some kind of education. Members of the IRA were often roped into standing guard at court sessions, usually against their will. It is not unusual for veterans in the Bureau of Military History statements to profess in believing the courts were a waste of time, and that their own efforts would be spent better fighting the British. Somewhere between April and June of 1920, the records aren't precisely clear, Dáil Éireann established the Irish Republican Police. The IR Police, a small sister organisation to the IRA, was created almost exclusively to serve Dáil Court-related duties. And these duties included guarding the court, or enforcing a number of punishments, including collecting debts or maintaining forced exile, since incarceration usually wasn't an option. At most sessions too, a clerk of the court would have been in attendance, noting down the basic names and details of cases, as well as the ruling of the court afterwards, and it is thanks to these people that the records that we have remain. And here is a portrait detailing the kind of thing that you might see at a Dáil Court. So you can see to the far right a IRA man in trench coat watching over proceedings, and as well there are a group of men at the tables with papers laid out before them as evidence. And this picture hangs in Cork Barracks. So section 2, now looking at the Offaly Courts. Offaly, which at the time was referred to as King's County, has a complex historical story. As previously alluded to, the recognisable county of Offaly began to emerge as a result of the first experimental plantations in Ireland, which commenced in the 1550s. This process shaped the political and social dynamic of the county in the long term. Towns such as Birr were revolutionised as a result. Even the name of the town was changed to Parsonstown in 1620 in honour of Sir Lawrence Parsons' family, who were locally planted gentry. The basic outline of this context is pivotal to truly understand the social and political context in which the Dáil Courts later operated in. As a result, by the time of the Irish Revolution, Offaly had a subtle but distinct divide amongst its populace, with the north of the county holding nationalist Republican sympathies, while the south of the county was less secure, with substantial pockets of Unionists. This unusual distinction between geographic areas of the county adds an extra layer of intrigue into the operation of the Dáil Courts. Of course, like many historical events, the complete picture of the Offaly Dáil Court operations may never truly be accounted for, given that some records have been lost. Over the course of time, and through warfare in this case, many of the original documents from the Offaly Courts appear to have vanished or simply been destroyed. The burning of the Tullamore Courthouse in May 1922, in the precursor to the start of the Civil War in Offaly, many court records were lost. In that fire, it is very likely that at least some Dáil Court records were destroyed, especially since the North Offaly District Court had been held in the Tullamore Courthouse since March 1922, after the British Army vacated it. Furthermore, the parish court records of Killederry were also likely housed in the Tullamore Courthouse, given that the transcripts get significant scorch marks. Other records were simply never returned following the Civil War and the winding up commission for various reasons. As an example, one of these reasons may have been political protest against Dáil Courts closure. As a result, the findings and the analysis of this research must be based upon the surviving evidence which exists through various primary sources, but I also must recognise the inherent limitations and conclusions which can be drawn at the moment, which are regrettably unavoidable. Fortunately, though, a great deal of primary evidence does remain on which one can reconstruct a map of the Offaly Dáil Court locations. We have been left with some kind of core records. There are 3 remaining record books, and 2 of these detail the operations of the Killederry Parish Court, located in and around the town of Dangan, or Phillipstown as it was then known. The other book holds the information for the Parish Court of Shinrone in the south of Offaly, as well as the District Court of Southern Offaly, which presumably was held in the same location as the Parish Court. Or at least the records were kept by the same person. From the research that I've done so far, which is almost exclusively on the Offaly Courts, and I've looked at some courts in Galway, there doesn't appear to have been any prescribed way for the clerk to keep the records of the court. And as a result, there's no systematic way to record information, or in fact, what information should be recorded. Between the Offaly Courts, there are even differences on the records in the style of record keeping between clerks, as you can see on the screen at the moment. For the most part, though, they did tend to note the same information. Theoretically speaking, as Justice Cahir Davitt recalled in his Bureau of Military History statement, there was to be a parish court for each parish area. A cursory glance of the surviving Offaly Court records, they indicate that this standard was not met, but it wasn't even required either. Within both sets of parish court documents, there is significant evidence that parishes were grouped together under a single parish court. For example, in one of the few case records that survive from the Shinrone Parish Court, Edward Jackson of Fort William brought William Lalla of Rossgrey, Tipperary, before the court over unpaid rates to the Dáil on the 2nd of June 1922. Whilst the matter was resolved before the case was heard in the courtroom, the original document indicating that the settlement occurred just before the sitting of the court, neither plaintiff nor defendant resided within the parish of Shinrone, or even within a neighbouring parish. In fact, Rossgrey, a border town situated between Offaly and Tipperary, usually thought of as a Tipperary town, but the Roman Catholic parish crosses the Offaly border slightly. Whilst the district court was supposed to serve just southern Offaly, the court strangely enough served more people from northern Tipperary than from Offaly. This serves to demonstrate that the structural plan of the Dáil Courts on the ground functioned differently than it was officially planned, but that the system adapted as necessary, thus demonstrating the flexibility of the Dáil Court system in the Midlands. The number of sittings, too, was adjusted as required. Whilst the Killederry Parish Court followed the Dáil decree to the letter, sitting at least once every month, in October 1921 the court sat twice. Such was the demand for hearings. The Shinrone Parish Court, on the other hand, appears to have only met twice, in August 1921 and in May 1922. The most likely explanation for such sparse sittings, I believe, is that the clerk of the court's book only noticed the case when they attended, and that a more regularly attending clerk's notebook had probably been lost. Beyond the court logs themselves, we do have other records to give us a greater insight into Offaly Dáil Courts activities. In Marie Coleman's work on the Longford Courts, she gives an insight into the situation outside Offaly, noting that how even in early 1920 the local press were giving detailed reports of the Longford courts and their rulings. Sure enough, the Offaly press also covered some Dáil Court proceedings, and a particularly valuable example of this comes from the Midland Tribune's report of October 2nd, 1920. The Tribune reported that the RIC and the British Army had antagonised the operation of the Thomastown Arbitration Court just south of Kilcormac. The paper's incorrect term of the use arbitration court is not accidental. Press publications with nationalist sympathies often use this term to disguise the dealings of the court as not to bring the British forces down on top of the court after publishing a general location in which one was held. Given that the Midland Tribune, however, was a unionist publication and opted to use this term instead, is perhaps indicative of the publication's perspective on the Dáil Courts. The Tribune's article from October 2nd also provides a description of those in attendance at the Offaly Court. It records that there were 3 Catholic clergymen, along with 6 prominent local solicitors, all from the Burr or Parsonstown area. Given that a parish Dáil Court judgment panel was of 3 judges maximum, of which a maximum of 1 clergyman could serve at any one time, and 2 others also could preside, but no legal qualifications were required, it is indicative that some solicitors in attendance were therefore there to represent clients at court, which serves to highlight the considerable success of the courts in Offaly. Since both local and legal professional support were required, and the fact that they were risking their careers by doing so, it points to a successful professionalised system which registered solicitors were willing to operate in. The RIC records are also a treasure trove for those researching the Dáil Courts. Since many of the original records have been lost over the years, the surveillance of the RIC and their network of informants provides the largest source base for historians. Although lacking in any substantial detail, the RIC reports paint a picture of how the number of Dáil Courts may have truly been. As you can see on the map on the screen now, the RIC records fill in the middle of Offaly where we have no written records, and so RIC cases are denoted by a red X. So you see, particularly in the middle band of Offaly, we have no paperwork that survives, but we do know that a number of courts took place and shows almost entire coverage of the county. In the period from September 7th to the 31st of October 1921, the RIC note 12 different towns, although there were sometimes multiple locations within the town, which were used to hold Dáil Court sessions within this small window of time. These reports were obtained usually within 24 hours of the court sitting, via local informants passing on information to the RIC and by other RIC officers who were dedicated to surveillance. And this is particularly fortunate for historians given that without these records, many of these locations in rural Ireland may have been completely untraceable and forgotten. Equally, the close concentration of the courts just to the north of Burr can be perceived as a gauge of public opinion within that area. Firstly, the fact that the RIC was still capable of surveillance by late 1921 and appears to have an active network of local informants in these areas indicates that the IRA's campaign had not neutralised the RIC as effectively as they had in Longford or West Clare, where at this time the courts were freely operating. Yet also the RIC was also increasingly powerless to do anything to prevent the open operation of Dáil Courts in these areas, especially since the truce removed the British Army from assisting in raids. Norris has noted that the courts were sometimes shut down in other parts of Ireland as political gatherings which were prohibited under the truce. District Inspector Fox attempted this in November 1921 when he raided the Tullamore workhouse, but failed, ultimately arriving shortly after the court's conclusion, which highlights the accuracy of RIC's reporting network, but also the difficulty of obtaining reports in time to disrupt the court's proceedings. Given the significant time delay in reporting the sittings of Dáil Court cases during the truce to Civil War period, it is highly probable that the RIC were unwilling or unable to intervene, but certainly not blind to the operation of the Dáil Courts. However, by the truce, in somewhat of an irony, the Dáil Courts had been established and had been highly successful at maintaining the objective of establishing law and order, something which the RIC actively welcomed. Thus, to some extent, allowing the Dáil Courts to function was simply in the RIC's interest. Tactically, though, the RIC were taking advantage of the interlude. Should the wider conflict have broken out again, the courts would have certainly been on the RIC radar. Thankfully, though, this was never needed. The presence of a localised informant network is also significant. As mentioned earlier, in 1921/22, Offaly still bore the scars of its plantation past. The lands of Offaly endured two separate plantations, the first under Queen Mary in 1556, which was of an underwhelming success, and with the second taking place in 1619-1620 under James I. Whilst the latter plantation could never be described as a true success, its impact, though, is certainly tangible in the census data, even by 1911 and in the events of the Irish Revolution. In the south of Offaly, IRA activity was significantly notably less when compared with the north of the county. In explaining this regional variation, even within a small county, Patrick Reardon, in his Bureau of Military History statement, testified that the 1,600-strong military barracks in Crinkle, along with the fortified garrison in the Protestant town of Birr, made operations extremely difficult in the south of the county, and as a result, operations in the county took place further north. In addition to this, he deemed the topography of the south of the county as not conducive for guerrilla ambushes, and the goodwill of the general populace was not considered to be guaranteed in the area, as the people of southern Offaly were not as openly supportive of the IRA as they were in other parts of the country. Whilst one must be very careful in generalising Protestants with Unionism and Catholics with Irish Republicanism, more evidence points to this connection in the Offaly case study. As Reardon noted, the Offaly IRA considered the support of the people in the south as suspect. Using the 1911 census data, it is notable that the areas in and around the town of Birr, which were highlighted as being home to a greater than average percentage of Protestants, the RIC was able to produce quite an extensive military surveillance record, suggesting that the population was at least somewhat more sympathetic to the British administration in Ireland. Yet Protestants were, nevertheless, still a minority in the town as a whole, and yet the presence of this significant minority was enough to deem the entire area as questionable. The local elections also offer another insight into the political leanings of Offaly. In the two local elections of 1920, especially for the Urban District Council election in 1920, these offer a greater insight into the true reality of the local voter feelings. It's especially important that both sets of local elections in 1920 were run under a proportional representation system, and thus the results of these elections would be far more indicative of political feeling. But one must also bear in mind that local elections are susceptible to misleading results, given that only the most politically engaged would turn out to vote, especially during a time of conflict. Tullamore, the county town located in northern Offaly, returned 6 ratepayers, 5 Sinn Féin candidates, 3 Labour, and 1 independent Labour, which represented a particularly disappointing result from a Sinn Féin perspective, having not won the largest share of the vote. But the Birr result would prove to be the sizable blow, with 7 Unionists being returned, along with 9 constitutional nationalists, mainly Irish Parliamentary Party, with Sinn Féin only gaining 3 seats, with Labour 2. The Urban District Council elections provide evidence that in early 1920, the Offaly public, especially in Birr, was not overwhelmingly supportive of Sinn Féin, or Irish republicanism for that matter. Whilst the Offaly County and Rural Council elections of June of 1920 offer a picture of near-total Sinn Féin support, Mary Daly has attributed that these elections were skewed by widespread candidate and voter intimidation across the county, suppressing alternative political voices. With all that now said, we have now discussed all around the Dáil Courts of Offaly, without actually looking at the actual courts themselves, or the rulings. The types of cases that were heard at the Dáil Courts offer a unique insight into the ordinary lives of people during the Irish Revolution. The Offaly Courts operated on every level, from county-wide parish courts all the way to an Offaly land auction case being heard in the Supreme Court in Dublin. However, for the purposes of this paper, only the original court records from the Truce to Civil War period will be examined, in order to focus in on the period which Kotsonoris has coined as the Golden Age of the Dáil Courts. Specifically, this discussion will focus upon looking at who brought cases to the Dáil Courts, the types of cases heard, and the nature of the rulings handed down by the court, but there are many different ways that this information could be used. In Northern Offaly, only the parish court of Kildare records survive in the National Archives, which makes cross-referencing near impossible in a like-for-like case study basis, given that Coleman examines the district courts rather than the parish, and Fitzpatrick fails to examine individual parish courts, choosing instead to examine the parish courts on a collective county-wide basis. Nonetheless, the Offaly Archives give a direct account of each case heard between 28th of September 1921 and April 3rd, 1922. Within this time frame, 62 separate cases were brought before the courts in 9 different sittings. The most common type of case heard at the Kildare Parish Court involved the late payment or non-payment of rates, a basic form of taxation levied from citizens to the government to pay for public services. The people of Offaly, like in the rest of Ireland, faced an unusual predicament where 2 different governments, namely Westminster and Dáil Éireann, both claimed legal sovereignty over the island, and both equally claimed the right to levy taxes from its people. The non-payment of rates became a prevalent issue following the 2 sets of local elections in 1920. With Sinn Féin holding 29 out of 33 county councils, the rates collected were retained by Sinn Féin-controlled councils for the use of both the local council and Dáil Éireann. This also happened to coincide with the height of the conflict which presided over the general breakdown of law and order, and thus many citizens opted not to pay and hoped to save the money for themselves. In this regard, the Dáil Courts are a testimony to Dáil Éireann's ability to establish themselves as a credible alternative to the British administration. Whilst personal stories are exceptionally difficult to trace, the example in the Kildare Court of John C. Gowing, originally of Killeen, is a particularly interesting one. Gowing served as a rate collector for the British government in 1911, but in 1921 continued to serve as a local rate collector for Offaly County Council after it came under Sinn Féin control. With this decade of experience, Gowing brought 18 separate cases before the Kildare Parish Court, aiming to force the payment of rates. In total, 8 of the cases were compelled to pay the charges owed, as well as court costs. 7 cases were settled before the court even began, and the final 3 were given verdicts of no jurisdiction because they exceeded the parish court's financial powers of £10, and therefore were referred up to the district court. In every Gowing case in which the court ordered a payment, the full amount owed was paid by the prescribed date. This sent a clear message towards those not paying rates, that Dáil Éireann had enough control and power in this part of Offaly to enforce their rulings, and the non-payment of rates or taxes was not acceptable. This proved particularly effective as 14 of the 18 cases were heard in a single sitting on the 12th of October 1921, and the last rates-related case was heard on the 16th of November. Similarly, in southern Offaly, rates proved to be the most common type of case heard, although to a lesser extent proportionally. Whilst only 5 cases of the Shinrone Parish Court survive, 2 cases were regarding rates, the other 3 were unspecified. Further, at the District Court for South Offaly, 8 out of 26 cases revolved around rates. It was this that was the most common case heard in the Dáil Courts of Offaly, and at every court in which the court records survive, this once again reiterates that the non-payment of rates is a particularly prominent issue for this county. Rates were also a common case heard in West Clare, although it is only the second most frequent case type that was heard in their courts. In Longford, Coleman groups all debt-related cases together, which also probably includes rates, which were actually at a very low level until a spike until April and May of 1921. Generally, therefore, rates were an issue in the existing county-based Dáil Court studies, but the extent to which very much depended on the local area in question. Of these case studies, Offaly's rate is without a doubt the most prevalent examined so far. More broadly, of the original Dáil Court records that remain to us from both parish and district court levels, just over half the cases involved incidences of debt, or 51.6%. The forms in which these debts took varied. Beyond rates, Other examples included the non-payment for goods purchased on credit or back payment on such items. Two such examples in the District Court of South Offaly were brought forward by Benham Westwood Limited, a local merchant firm based in Ross Grey, and John Tierney in two separate cases. The Gunnell family and John Tierney had obtained materials to build properties, but they had failed to maintain their repayments, in total building up substantial debts of £46 8 shillings and 9 pence and £39 5 shillings and 10 pence respectively. The presiding judges ordered for the full repayment in both cases, although in instalments of between £1 and £2 per month rather than in a lump sum. However, unlike in Northern Offaly where the rates judgments were honoured by the defendants, neither decree was ever paid in Southern Offaly. This fundamentally draws another distinctive line between the two halves of the county. In the north, the Dáil Courts had the IRA to perform their duty at the courts and enforce the decrees where necessary, whereas in the south, the Dáil Court control, and by extension the influence of Dáil Éireann itself, had significantly less control. The remaining bulk of the cases which the court has heard are difficult to group together given their multifarious nature and typically low rates of occurrence. Given that the District Court heard appeals from the Parish Court, the cases heard tend to be quite similar, although very few cases went directly to the District Court. These assorted cases range from property possession, various trespass charges, breaches of contract, and in some cases even physical assault. In Longford, Coleman defines these types of cases as mundane, which typically reflected the rural nature of life in the county, and a direct comparison can be drawn at the Offaly Courts. The Galway Dáil Courts also appear to have similar types of cases as both Offaly and Longford, albeit in far greater numbers, although this is an area in which significantly more research is required. Fitzpatrick's case study of Clare also exemplifies the differences within divided counties. The parish courts of East Clare heard 104 cases from September of 1921 to February 1922, but yet over the same time period in West Clare, they heard 334 cases. Given Offaly's recent history of agrarian unrest in 1913, it is intriguing that very few land-related cases records remain. A notable example of this, however, might be where Thomas Phelan, who was evicted from his land tenancy for malicious damage. One such explanation is reviewed by James Riley, a captain in the Westmeath IRA, but someone who had frequent movement in Northern Offaly, who recalled that land disputes were usually settled on the spot, and that they did not require a courtroom. Given that not enough evidence survives in regards to land cases in Offaly, Coleman's argument that the Dáil Courts had a reputation for conservatism where land was concerned cannot be further explored here. Ultimately, more research is required of the Dáil Courts on a county-by-county basis in order to definitively define the typical Dáil Court experience. But in the very few Dáil Court cases that have been conducted so far, there is evidence to suggest that the types of cases heard seem to be of very similar natures throughout the island. Whilst a great deal has already been said on the matter of demographics in relation to the location of the courts, it is also worth utilising the known information to examine the backgrounds of those bringing cases to the courts. Given that there was a tendency for people to remain in their local area, the 1911 census has been used as a cross-reference to track individuals, and specifically their religious affiliations. For the most part, the recordings at the court have provided the necessary details to accurately track the majority of both plaintiffs and defendants at the Offaly Dáil Courts. Whilst there was no official system to log the cases, the records that the clerk provided generally noted the townsland, as well as the names of the defendants and plaintiffs, and their occupations. This was especially so in Kildare, where there was a very methodological approach adopted, whereas in Shinrone, sometimes these details were missed. The clerk usually took a note of the townsland, but never their occupation. In cases where it has been challenging or impossible to accurately distinguish within reason the correct individual, such as the description of a Miss Evans in the District Court of South Offaly, those results have been highlighted but excluded from the percentage totals now on the screen. Their inclusion within the statistic would skew the data, which can give it false impressions. Despite being an experimental plantation county, Offaly remained a mainly Catholic county, and thus it should not be a surprise that the majority of cases across all of the Offaly Dáil Courts, it was mainly Catholics bringing cases to the courts. In fact, in total, 76% of the total plaintiff numbers were Catholic. With the exception of one Jewish plaintiff, who was the only non-Christian case in the courts, the remaining 21% were made up of Protestants. Given that the census data indicates that approximately 12 to 16% of Offaly's population were Protestant, proportionally it is clear that Offaly Protestants were more likely than their Catholic counterparts to bring forward cases to the courts. Equally, Protestants were far less likely to be brought to court. Only 5% of the defendants were Protestant, with the remaining 95% Catholic. This raises an interesting point that the courts were not used to target the inequality between the poorer Catholics and the wealthy Protestants of Offaly, perhaps in part due to the reputation of the conservative judgments handed out. In terms of wider academia, it would be an interesting examination to compare religious affiliation within the Offaly Crown Courts of the period, and then compare the two differing court systems, but this remains a project earmarked for the future. The motivations behind bringing someone to court are difficult to definitively state, given that the motivation of an individual is hard to prove at the best of times, even today. Speculations can be derived from the information at hand, though. In the Offaly examples, both census record and Dáil Court records endorse that all Protestant plaintiffs were business people or traders. For example, at the District Court of South Offaly, Charles Cook of Clough Jordan and Bell and Wellwood Limited of Ross Gray both brought forward their cases regarding goods sold on credit, but the defendants didn't keep up their repayment. In the lowest value Protestant plaintiff case that can be identified, Mrs. E. Brady of Dublin and Miss Fanny Collins of Dangan indicated that they were property owners seeking the payment of rent from several of the residents at the properties in Kildare Parish. With all these cases being worth a reasonably significant amount of money, differing between 5 shillings up to £47, it is likely that the plaintiffs simply wanted payment, and with the decline of the British petty courts, the Dáil Courts were simply a tool of obtaining their own personal justices and getting their finances back. Whether or not those Protestant plaintiffs intended to or not, as Coleman notes, those who resorted to the Dáil Courts played a central role in the achievement of Irish independence. Another assertion of the academic literature already published on the national Dáil Courts is the perception of the relative success of the courts came in conjunction with the decline of the British Crown Courts. In Offaly, the decline of the Crown Courts was particularly noticeable, especially in Tullamore, because the British Army had occupied the courthouse in February 1921, rendering it unable to operate as a civilian court until June 1921. The year 1921 could be described as the annus horribilis of the Offaly Crown Courts. The condition of the courts had gotten to the point in which the RIC were compelled to visit homes in Cadamstown, commanding jurors to attend the local assize courts in May. Even worse, despite the best efforts of the Crown forces in pressing people to attend, only 4 out of 37 grand jurors who had been summoned even attended in July 1921, which effectively meant that the court couldn't function. Having said this, the Crown Courts did continue on in some form. The local and national newspapers provide insight into these petty sessions. For example, as late as November 1921, the Tullamore Petty Session issued fines to locals based on those who had violated lighting regulations at the time. Further, the Nenagh Guardian and the Kildare Observer published Offaly Crown Court information such as juror summonses and court proceedings, but never at any significant depth. Despite the Crown Court's struggling condition, martial law was never enforced upon Offaly, which would have removed the need for jurors, since martial law was reserved only for those counties deemed the most rebellious. Whilst Foxton has asserted the role of the IRA's intimidation campaign as to why jurors chose not to attend, IRA man Joseph Connolly recalled that the people actively embraced Dáil Courts and the Irish Republican Police, as they were the ones given credit for restoring law and order during the most turbulent of times. Perhaps another contributing factor in their decision to go to the Dáil Courts was their reputation for fair and conservative judgments. Historians of the period have often asserted that Dáil Courts had a reputation for conservative judgments. Coleman and Fitzpatrick have both asserted this notion in their respective works. In many ways, this is the dichotomy that lies at the heart of the Dáil Courts and epitomises their nature. The Dáil Courts existed in an inherent contradiction. Whilst on one hand, this was a revolutionary court system aiming to usurp the Crown Courts, yet their ideology was innately conservative. Offaly continues in the trend already identified by Coleman and Fitzpatrick. In her analysis, Coleman notes how in Longford the judgments certainly tended to favour the property owners. For the case of Offaly, this definition could actually be expanded to favour the broader establishment. In the Kildare Parish Court, the Dangan Coursing Club brought John Maloney, aged 14, and George Dronin, who has been incorrectly identified as Charles Dronin in the Freeman's Journal, to court over poaching a rabbit on their premises. The court handed down a harsh fine of £2 and 15 shillings to be paid over the course of 3 months. Other notable examples include the Munster and Leinster Bank, based in Clough-Jordan, Tipperary, who brought Anne and John Kavanagh to court over debts totalling £14, 12 shillings and 3p. Once again, the court ordered full repayment in swift instalments. The Dáil Courts, however, did not blindly accept the word of the plaintiff. In fact, by following a unique mixture of British law, revived idealistic interpretations of Brehon law, and good old-fashioned common sense, the Dáil Courts entrenched their conservative reputation even further. When Thomas Phelan accused Joseph Murphy of threatening and abusive language at the District Court of South Offaly, the presiding judges quickly dismissed the case due to a lack of sufficient evidence to prove Mr. Murphy's guilt. In a Kildare joinder case between Catherine Murran and Mary Murphy, both suing each other for abusive language, once again the presiding judges threw out the case over a lack of evidence. In total, though, very few cases were dismissed. Out of the 93 cases that we can find in the original Dáil Court scripts, just 9 were dismissed, making it a fairly unusual outcome of the court. More commonly, the court was adjourned to allow for the collection and presentation of evidence at the next sitting, where a definitive outcome would be given. If one removes the number of adjourned cases, assuming that those cases then did return, which there isn't always a record of, the number of settled cases across the Offaly courts and case types, 57% of final judgments resulted in the court ordering the defendant to pay compensation, usually along with a small fine and the costs of the court. As already discussed, these orders were not always followed, especially in the District Court of South Offaly. In conclusion, then, any attempt to place Offaly into the national context is a difficult challenge, given the lack of Dáil Court analyses of the 31 counties in which they operated. Given the general neglect of both County Offaly and the Dáil Courts as topics in academia, there is much more to examine and reveal on these courts. Comparatively speaking, there are substantial similarities between Offaly, Longford and Clare based on the information available. The Dáil Courts in all 3 counties heard similar numbers of cases and similar case types, although Offaly experienced substantially more rates-related cases than the others. Offaly's courts also heard a proportionally greater number of Protestant cases, which may be considered a testimony to their success, but detailed comparative data has not been compiled for Longford or Clare on this matter. Overall, though, it would be a fair assessment that Offaly was a fairly typical case in terms of the Dáil Courts, but this perception may well change after more research. This paper has provided an analysis of the Dáil Courts of County Offaly for the first time, and presented a social snapshot of Offaly in the period of 1920 to 1922, which has not been previously considered. It is hoped that this work will be built upon other researches in future, so that we can explore the many remaining questions surrounding this incredibly interesting court system, and acknowledge their contribution to this lesser-known avenue of the Irish Revolution.